today. So let me give a quick intro here on Preston, and then Preston, I'll turn it over to you. So Preston Bukaty is a GRC consultant and privacy lawyer specializing in information security and data privacy compliance projects, from data mapping initiatives to gap analysis and remediation planning. His background and experience in operationalizing compliance as a global software company's privacy program manager and GDPR project lead give him a strong understanding of the legal issues presented by regulatory frameworks. Preston lives right here in Denver, Colorado, and Preston's legal experience and passion for technology make him uniquely suited to understanding the business impact of privacy laws and compliance regulations. Through hands-on engagement with data mapping, DPIAs, and data protection agreements, Preston understands the challenges that come with far-reaching regulatory frameworks. At the same time, he values the policy rationale of data privacy legislation and the need for any organization to properly manage personal data. As a result, Preston aims to provide practical guidance on managing business risk while demonstrating an effective compliance program. And I can say, having worked with Preston, he's a great resource to have on your team for these sorts of things. So Preston, turning it over to you. Looking forward to the presentation. Thank you. And I will be fielding questions that come in throughout the event and queuing those up for you as we go through slide transition.
Okay, awesome. Well, thank you, Carlin. Thank you, Scott. I know Carlin just kind of went over some of this, so I won't go too deep, but I did want to stress two things on this slide. Number one, kind of like Carlin said, I've cut my teeth in going through these laws and coming from it truly from that legal background. It's been an interesting evolution the past 5-6 years. My impression of it is very much the historically, stodgy old legal departments, often an impediment to business, historically not a group that's the most tech savvy. In fact, I know plenty of lawyers to this day that still dictate things with a dictaphone and then handwrite notes and all that good stuff. We're in this weird position in society where technology is exponentially increasing in terms of its capabilities, in terms of the data it can store in just sheer size, but then also the value of that information, right? Whether it's military, economic, what have you. And so I think around the world, right, we've heard all sorts of acronyms over the past couple of years, like GDPR, CCPA. I think around the world, different countries and different governments and different companies and organizations are recognizing the importance of their data. And so we're all trying to figure out, okay, but what does that mean in a mature society, right? What is safe data handling? What's good data hygiene? What is good data privacy? What's too much? What's not enough, right? And the thing I always try to tell people is, imagine you were born 100 years ago and cars were a brand new invention, right? Nobody knew car insurance, accidents, fender benders, all of that's very easy for us, right? You could get on the Geico app and within a couple of clicks, you'll know that if there's an accident, who's at fault and how much does it cost. The world is kind of coming to that point with data privacy laws, right? And California is leading the charge on that. And I think there's two reasons. So keep in mind on the bottom right of my slide, right? What's coming up in these slides, they're going to be a little bit text heavy. And I did that on purpose because I'm really trying to walk people through this. And hopefully these slides can serve as a written resource later to remind yourself, to refresh yourself. So you'll start to see as we go through the slides. Of course, if you've got questions, there's my contact info and more about my background and books and content and other material that I've put out on this topic. Back, last year was such a blur, but I guess it was spring of 2019, I wrote a book on the CCPA. And then, of course, as California's legislature hemmed and hawed, I was sitting there making my red lines and updates and trying to push that through last winter as well. So hopefully some more info coming on that as the law continues to evolve. So there's a long history here, kind of like Scott had mentioned earlier, right? It seems surprising. We're already talking about CCPA 2.0, AKA the CPRA, but it didn't just evolve out of a vacuum, right? These laws have come from somewhere. They have been molded and manipulated over time. And like I just told you, if you think about it, Europe really kind of kicked a lot of this off several years ago with the GDPR. and the US is following suit. California is one of the first states to jump into the foray of data privacy laws for a handful of reasons. Presumably, most of them are obvious, right? There's a huge component, multi-billion-dollar businesses located in California that make a lot of money off of data, Google, right? Facebook and others. There is also a history of privacy and intellectual property in California, right? So think about back to the 30s and 40s, movies, people's images of their face, their autographs, kind of that cult of celebrity. California already has an interesting legal history in how do we protect people's information, right? Like literally, even a signature on a contract might be worth something to somebody. And then the other thing too is, California is usually one of those states that kind of tends to do its own thing. We've seen that with some other regulatory areas, and by virtue of the sway that they have, right? It's a giant state, huge population, a lot of money in and out. They kind of can dictate in terms of what the rest of the states will do, right? If they're the first ones to jump into the pool, other states, and we've seen those lately, like Virginia, Oklahoma, Nevada, New York, Florida, Texas, Washington, all kinds of them, they're going to kind of follow suit. So today I want to talk about what exactly is the CPRA, how does it differentiate from the current law in place literally right now, which is the CCPA, and hopefully by walking through this journey, we can better understand where the law came from, where we're at today in terms of what we need to do to comply, and maybe where this stuff is headed in the future. So a bit of a background for you. This gentleman on the screen is named Alasdair Mactaggart. And as far as I know, from what I could glean off the internet, Alasdair is a rather well-to-do real estate investor. And so he lived in California, friends maybe with some people that worked at Google or Facebook. And so as the story goes, he was out having beers with some of his friends, and they were talking about data, and they were saying, hey, if you really knew how much information we had, it would blow your mind. And Alasdair, perhaps, rightly or wrongly, maybe he had too much free time and too much money, but he got a bunch of consultants together and drafted the first legislative attempt at a privacy law in California. And so this was going on all the way back in about 2016, 2017 timeframe, right? If you guys remember, the GDPR came out in 2016 and took effect in 2018. So this was all kind of going on during those rumblings. And the interesting thing is that California, if you have enough signatures on a ballot, you can put that in front of the voters, right? You don't have to go through city council. You don't have to get it approved. Or if you get a certain number of signatures, people will vote on it. And that's exactly what they did here. Alasdair Mactaggart took his version of the bill, did some, political polling, looked like it was polling very favorably, right? People were really into this idea. Well, naturally, the companies based in California that might be impacted by this law, right? The Googles and Facebooks of the world, they pushed back quite a bit. Long story short, what that ended us up with is sort of a hodgepodge of legislation. Because if you think about it, there was this very pro-consumer piece of legislation drafted by Alasdair and his team. Corporations pushed back. They lobbied, senators and congresspeople in California tried to strip this version down. We ultimately met in the middle. The governor signed it in an absurd amount of time, right? Something like less than a week or two. I know for those of us in private industry, that's not that long, but hey, that basically within a couple of months, the government of California was almost forced into this position to have this law, right? It was very popular. Alasdair was going to take it to voters, and if they didn't do what he liked, he could go to the voters, right? So there was sort of this compromise, and you can see on my calendar sort of timeline here, that's where we sort of start this story back in 2018. And so over the course of time, right, this law was written, published, it was promulgated for public comment. And so there are a couple of cleanup bills to amend it, to clarify language. Like I just told you, right, it was sort of rushed through over the summer. There was honestly even straight up grammatical errors that needed to be fixed. So you see AB 375, that stands for Assembly Bill. SB 1121, that stands for Senate Bill. None of these were really major ground shifts in terms of privacy rights, right? And I want to stress that the law that we came out with, right, that was signed by the governor in 2018, that same essential pattern, we can see it in the GDPR, we can see it in the new law, but over time, especially if you follow blogs and news outlets like I do, you get hammered with updates, right? They're constantly updating this law, but keep in mind, they're just trying to streamline it, clarify it, take in public comment. And so that's a lot of what happened over the course of 2018, knowing that, hey, this law will take effect in 2020, right? So it is published in the summer, fall of 2018, gives companies about a year and a half to get ready. Well, you see that on the bottom there in the kind of red orange. Around that time, this group called Californians for Consumer Privacy were creating some trouble. And so what you can see going on, actually, guys, if you think about this, right? So this law was promulgated, published in the summer of 2018, and over time, there were these little legislative amendments. Not to sound cynical, but what happens when politicians make little legislative amendments, right? They start chipping away, they start inserting things that they want that would serve their constituents. And so over the course of 2019, Alastair Mactaggart was thinking, hey, I brought you a very pro-consumer law, and you guys wanted to walk it back because you didn't think it was suitable for businesses. Okay, fine, right? We had a compromise. But you have since pushed that compromise even further and further away from my original goals, right? You have diluted this bill, diluted consumer rights. You're making it easier for businesses to comply, but you're taking away our privacy rights that we tried to go for. So that's kind of what happened. Right at when this law, the CCPA, took effect in January of this year, not long after in the spring, this group, Californians for Consumer Privacy, announced, hey, we've basically rewritten the law. It's more akin to our first draft, very pro-consumer. And oh, guess what? We have nearly 1 million people who think that this should be the correct version of the law. And so, despite this legislative compromise and probably no shortage of backroom deals, the group basically said, hey, the CCPA, great, thanks, but we're going to take this one straight to the voters as it's written anyways. And so you can see, right, as we've crept along this year, well, really 2020 and into 2021, the CCPA is the active law today. It is still in effect as it was written. The CPRA was voted on last November, right? So they got all these signatures, they took it to vote in November at the same time we were voting at the presidential election, and it passed. Passed with 60 or 56% support. So the CPRA is going to be the new version, and that takes effect in 2023, January 1, 2023. That's when we got to start worrying. The one tricky caveat you see here in yellow is that look back period. And what goes on there, guys, if you think about it, right, under these privacy laws, people often have a way to access their data, right? Give me a copy, delete it, what have you. California legislature is saying that will apply from 2022 to 2023. People can start exercising their rights on January 1st. So for example, if I said, hey, it's January 2nd, what data do you have on me? I would expect you to be able to tell me 12 months backwards, even though technically the law has just taken effect, right? So it's all kind of confusing. There's a bunch of overlapping timelines, but I'll try to make it a little bit easier for people.
Hey, Preston, just to interrupt real quick, we already had a question come in, and I'll take a shot at really kind of summarizing this. This is coming from, you know, a business, let's say, that's in Europe, and they've been under GDPR regulation, and now you look across and they see, hey, California now has, you know, some privacy legislation that they probably need to comply with. And so the question here is really around, you know, what's the best way to accommodate for that? And the question here is, do I write supplemental privacy notices? Or, you know, in saying that if you're a resident of California, read this supplemental privacy notice, you know, and really what's kind of the best way for, you know, GDPR compliant businesses to start looking at being compliant with CCPA.
Yeah. Okay.
I
Great
say
question.
CCPA just because it's first before CPRA.
Yeah. No worries. So I sort of have two opinions on this. I think on the one hand, yes, you can come up with California specific stuff. And I say that because inevitably, in my opinion, what you will be left with is, well, we've got a certain set of policies and procedures that apply to European data subjects. We've got a certain set of policies and procedures that apply to people in California. And, for those of you that are geography buffs in the US, you're going to have 49 other sets of rules for every other state in the US and then different countries. So I think it's possible. It just kind of depends on what type of organization you are, right? If you are an umbrella organization with a bunch of different business units that attack a bunch of different markets, it may make sense to sort of target your compliance messaging that way. On the flip side, in my opinion, that is a bunch of work. And I think you will be kind of, to a certain degree, reinventing the wheel, because these privacy laws aren't that different from jurisdiction to jurisdiction, but they are different. And so my advice would be try to blend them together as much as possible. As an example, you'll see a couple of slides from now, we start going through rights under the CPRA. And I'll tell you from experience as a guy, even who's written marketing content, I could describe those rights in any number of ways, right? I could make a list of 5, a list of 10 bullet points, whatever marketing wants me to kind of do. But at the end of the day, it's all the same basic stuff, right? People need to know what data you have about them. They should be able to get a copy. They should be able to delete it in certain circumstances. So my ultimate answer to the question is, it's about trying to blend these laws together, see where there are overlaps, and tackle that with a common compliance strategy. And then you can focus on the micro areas that have these weird little nuances. Because for the most part, these laws really are based on the same fundamental elements. And they're kind of taken from GDPR, right? It's about notice so that people are aware of what data you have, right? You have a policy on your website. It's about access. They can get in touch with you, perhaps get copies. And then, to that end, deletion, maybe they're editing some of their data, what have you. But they're really not that radically different. And I say that because if you look at the requirements of what CPRA says you should put in a privacy policy, it's going to be very similar to the GDPR, right? A great example goes back to my car analogy. When GM puts safety manuals in cars, whether they are selling it to Finland or Florida, it's going to be the same kind of basic stuff, right? Wear your seatbelt. Here's how the airbags work. Here's how the check engine light works. So that's where I started this whole story. My opinion is that in 5 to 10 years as a society, whether it's regions or countries or maybe the whole globe, we'll all start to have a common sort of set of requirements for these laws, just like car safety, food safety, any other thing that a lot of people do, right? Like hopping on the internet.
Great, thanks, Preston.
Yeah. And so I'll try to talk about that in more detail, because I really think that question is prescient for those of us here in the States, because we are kind of in this holding pattern. If the federal government comes up with a law, that's great. That's one law for everybody. If they don't, more states will keep coming up with their own laws. And I can tell you from experience, although, like I just said, they're very similar, there are minor nuances. And it's like, hey, I know my job isn't legal, but I don't want to have to do 50 different laws that are all basically the same. Let's just all agree on one common framework, right? So the CCPA, California Privacy Rights Act, I've actually included the statutory citation and the hyperlink in the slides there. And I did that because I think sometimes people think about these laws as like a big, mysterious, burden or beast. And if you think about it, they're actually not. It's just a bunch of words written. And frankly, in my experience, usually they're not well written. But if you click on that hyperlink, it'll take you to the website for the California legislature. And this is all publicly available, right? So you can go through the law line by line and try to figure out what you're supposed to do. Like I said, sometimes the issue is that the people we have in government are long-winded and they use old-fashioned language, so it's hard to understand what they mean. But you see, one of the things you'll find is the effective date, right? And so the CPRA is similarly written. Like if you literally hold up the two websites side by side, you'll see that they're very similar in style. And so hopefully you can go through and try to parse, all right, what's the same, what's different? You see that the CCPA remains in place today. So we've still got some time before we really need to get worried. And you see here what I've tried to do at the bottom of the slide. I'm trying to boil it down into the really common and core basics, right? Basically, what you have to do under this law, if I had to explain it in an elevator pitch, you have to tell people when their data is being collected and what it's going to be used for. And you have to give them an opportunity to play a part in that process, whether that is asking you questions about it all the way to deleting it in certain circumstances. You got to give them a chance to play, right? So you tell people what data you collect, what you use it for, and then you give individuals some sort of rights to participate in that process, right? Whether it's accessing their data or requesting it. Now, the key question for most people at the start of this process is, all right, but do I have to deal with this law, right? Does it apply to me? Does it apply to my company? This is interesting for the legal nerds in the room, like me. It may not be interesting to all of you, but the tricky thing to think about here is historically, the way that laws work in the United States is complicated because it's one country with 50 mini countries within it. So the question always becomes, well, how do I know when I have to comply with a law in another state, right? I'm in Denver, Colorado. This is a California law. Does the law apply to me, right? I'm not in California. The sheriff can't come arrest me. So what are the chances I get caught, right? The question under these types of laws was actually already settled by the Supreme Court a couple of years ago. You guys may remember it. It was about Amazon charging sales tax for sales made over the internet. Because if you're old like me, you may remember you could buy things on the internet and you didn't have to pay sales tax and maybe save a couple bucks. The logic was, hey, Amazon is based in Washington. And so if they're selling shoes in New York, why does New York get a cut? That is an exchange between a Washington organization and a citizen somewhere else. Well, that's not how the internet works, right? I know that was kind of a roughshod example and explanation, but the Supreme Court in that Amazon case basically said, hey, the internet allows companies to be physically located in one spot, but do business in a ton of different spots all at the same time. And if that's the case, if they are going to reach into different economic markets, they need to play by those rules, AKA they need to pay taxes, right? So the same logic would apply here. If you are not physically located in California, that's great, right? Again, the sheriff can't come kick in your door, but the law would still apply to you if you are doing business into California, right? So it applies to the data of California residents. And as a result, that's something for you to think about, especially in regards to that last question, right? Am I going to come up with a different compliance strategy for Europeans versus Californians? Well, what about people that are on vacation and technically aren't citizens, but they're there for a month because it's COVID and they rented an Airbnb? It gets confusing, right? Now, the hopefully helpful thing to help limit the threshold of this law doesn't apply to everybody doing business in California. It only applies to certain organizations. It only applies if you have at least $25 million in the preceding year's annual revenue. So that's one minor change from the CCPA to the CPRA, is that piece of the preceding year's annual revenue. Minor change, right? But the old law said you had to have 25 million in revenue. The new law says specifically the last year's revenue. Your organization must also comply, though, if you alone or in combination buy, sell, or share the personal information of at least 100,000 consumers or households. So a couple of things there that have been changed. One thing to understand is that California has a very interesting definition of what constitutes a sale of data. And it is not a sale in the sense that we all think about it day to day. they've actually said it could be an exchange for any valuable consideration. So it's not just, hey, I gave you data and you gave me a check. What if I give you data and you give me a discount? Or I give you data and that furthers our relationship? Or I give you data and that gives me access to a market? California would say, hey, you are trading that data for value. You're making money off of it. Uncle Sam wants his cut, right? So the thing to understand there, though, is the CPRA actually raised the threshold. That previous number, that 100,000, I believe was 50,000 consumers or households. So they've actually tried to raise it a bit and basically focus more on companies that are processing a ton of data. And then you see finally at the end, the law applies to you if more than half of your revenue comes from the sale or sharing of personal data. So one quick personal opinion here that I'll enter in. I'm seeing laws go this direction in the United States, where there is a certain set of rules that apply to companies that make money off of personal data, like data brokers, versus other people who just use data to accomplish day-to-day tasks, right? A lot of you submitted your email to join this webinar. We're not making money off of it. We just needed to send you the link to log in. That's wholly different from an Experian or some of those other entities that collect all this data, and actually that's their business model. So as you can imagine, the government's going to say, hey, if that is your business model and you're making money off of it, we're going to have to take a piece of that in order to regulate it and make sure it's safe. If you're just using data to accomplish normal business-to-business tasks, that's a wholly different game. And we still need to be safe about it, but it's a little easier.
Hey, Preston, just another quick question. On one of your other slides, you talked about kind of the rights. And one of those rights was, including the ability to request deletion of the data or requesting that data not be sold. So the question comes in, it's like, where's the line drawn between a request and a demand?
I guess that's a good question. I'm afraid I would answer that with a question of my own, because I think, and I know we can't dialogue, but Carlin, maybe jump in, because I'll tell you guys from experience, when people submit a data subject access request, and I do the air quotes, that's what it's called under the GDPR, in the the nerds like me, we call them DSARs, right? So somebody emails in, give me my data. Those, in my experience, can be very polite interactions. Hey, I'm curious to know what data you have on me. I've also gotten emails that say, I hope you die from COVID, and I can't believe you're taking all this data from us. Unfortunately, I think you have to respond either way. So regardless of the tone, you probably have to do your best to honor it. And you're usually trying to walk people back because you don't want them to get angry and turn around and do something to you, whether that is an angry rant on Twitter or an angry email to the Attorney General. But I don't know. And I guess that's where I'm getting caught on the question, is that difference between a request versus a demand.
Yeah, I think that's, I think you're probably right. If you're under GDPR or CCPA regulation, then you as a business will need to comply with that request. You could call it a demand if you want, but you're gonna have different timelines to respond to that. And then you're gonna need to, provide some transparency, right, around what you're doing with the data. So I think it's important that you build out your privacy program in such a way that you've got that, timely capability and the flexibility for that.
Yeah. And on that point too, Carlin, if I may, is like I said, like a lot of, even the GDPR, this law, but even the GDPR, a lot of these consumer rights that have been granted, they're not all encompassing. There's nuances. They only apply in certain situations. Now, we know that because we read the legislation, we all get together on these webinars, but every Joe Blow on the internet might not know that. And so part of your program may involve an element of kind of marketing style communications, education, and outreach, because if somebody emails you angrily and says, delete my data, and technically it doesn't apply in that scenario, and it would be too expensive or difficult for you to do it. So you're saying, we don't have to and we can't. Well, okay, fine. But how are you going to pass that message back to that individual who may not fully appreciate that you are doing things compliantly because they just saw on Facebook, you know, that, hey, I can have my data deleted, please delete it. So it becomes a little bit of an outreach mechanism, communication mechanism. When I've done it, I try to connect usually with somebody who has insight into the sales or marketing group, so that I can be like, hey, I'm taking the same tone, sounding the same way, hopefully turning this person around and maybe bringing them back to buy something else or give us a good review or whatever it may be.
Yeah. Thank you.
Sure. So some other quick comparisons between this new law, the CPRA, and the current law, the CCPA. So one of the things, kind of like we just talked about, hey, deletion rights, those are limited in how they would apply to unstructured data. So what has happened there? Basically, in my opinion, a bunch of businesses over the past couple of years had said, oh my, hey, how are we going to delete data that's stored off site or it's in tapes where it's fully encrypted and we can't crack back into it? Right, so the law has kind of granted some caveats about, hey, if it's no longer personally identifiable, doesn't need to be deleted. You see, like I just said, they've exempted more small businesses by raising the threshold. So that's something to understand from the sheer construction of laws, right? Not all laws apply to everybody all the time. So when you're looking at laws like the CPA, CCPRA, you have to look at the covered entity, right? That language is taken from HIPAA. But I'm saying what you got to do is, who does the law apply to? It applies to a business. How do they define a business? That in turn would give you more detail. Another common sense exemption you've seen here, when the law first came out, it was covering all personal data all the time. And since then, they have walked that back a little bit to basically say, look, the CCPA rules several of these rights that we're about to get into, they're not going to extend to people who are acting in an employer capacity, or people who are basically doing business to business work, right? And so to that end, unlike the GDPR, the CCPA would not require that you create a privacy policy and all of these processes and whatnot for your employees, right? If you have employees in California, that's great. You're welcome to do it, but this doesn't apply to them. This law applies to consumers, right? So it doesn't apply to employees, it doesn't apply to people kind of acting as directors, officers of their organization, that kind of thing. And as you can imagine, that's not terribly crazy, but it maybe gives your HR department a bit of a breather. I would argue that it's coming down the pipeline eventually. It's probably a good idea to have those kinds of things for related legal issues like labor law and, you know, hey, if you're on a company laptop, who does what, who owns the IP? But CCPA, we're leaving it out. They basically kicked the can down the road and said, hey, this law doesn't apply to B2B or employee-employer data. Now, the interesting sort of development comparing the old law to the new one is this new definition of sensitive data. So a couple of slides from now, we'll get into these definitions, but what you're starting to see some states do, and that's why I referenced that New York law, what they've done is said, well, there is personal information, and that's information that could be used to identify an individual. And then there is sensitive data or sensitive information, similar to the GDPR's concept under Article 9 special categories. So typically, sensitive data is starting to be defined as race, religion, political affiliation, sexual orientation, medical history, biometrics like fingerprints or eye scans or facial recognition, that kind of stuff. And if you think about it, that makes sense, because these laws a couple of years ago were talking about all personal information. It was incredibly broad. And now the world is saying, okay, well, you know what? Names and phone numbers and business emails, probably not that big of a deal, but retina scans, blood type, medical history, sexual orientation, that's typically things people care a lot more about. And so these laws are trying to create different sets of rules. We'll see, like I said, as we flip a couple of slides from now, we'll get into some of what those are. Now, an interesting new right, quote unquote, is this right to data minimization. And so the idea here now is that California is going to require that you come up with some retention limits for data. right? So no longer just saving it indefinitely or as long as you need it. We need some actual dates, right? It's saved for 7 years and then it's erased or encrypted or what have you. We also see that this look back period I mentioned earlier, right? So a right to know, access, and receive personal information collected before the 12-month look back period. So you remember that slide, right? The 12-month look back period. What this piece is saying is that actually some of these rights are going to apply to all the data you've ever collected. That's the way I read it, at least. I think my impression of this is saying, hey, for most businesses, we're going to set a little timeline on what information you would need to have to respond to a consumer request, right? So if somebody says, what data do I have, or can you delete it? 2020, we're looking back to 2022. In certain cases, you may have to go to the beginning of time. In my opinion, that's aimed at a company like Facebook, because if I go to Facebook and say, delete my data, I'm clearly wanting the whole enchilada and not just what you did for the past year. So I think that's going to be kind of a confusing one. We'll see how it plays out. Just so you all are aware, with the last cycle of this, with the CCPA, the Attorney General's office came out with some rules and promulgated guidance on how to best comply with the law, right? So they actually had a couple of meetings before COVID, and then it was virtual public consultations. Presumably we'll see the same thing. So I know some of you may be going through this, scratching your head like, what the heck does that mean? I'd be willing to bet you a beer that people in the California legislature don't know either. And they've said, well, that's the Attorney General's problem to figure out. So you can see some other stuff, right? New definitions and obligations related to cross-context behavioral advertising, giving people the ability to opt out of data being collected and sold for targeted ads. Something I've seen in another new law this year, Virginia has the same thing, would allow people to opt out of targeted advertising. So what does that mean? You may need to reinvestigate how you orchestrate cookies on your website and cookie banners, cookie compliance, that relates to an EU law that is technically separate from the GDPR. So you see it all starts to come together. Now, an interesting one here on the bottom, they amended breach liability to actually go back to what several states have in this area. So let me explain. A lot of states today, in fact, all 50 states have a data breach notification law. So if you have a data breach, right? What is a data breach? You'd have to go find out every state. But if you have a data breach, you have to tell people about it. A lot of laws define a data breach as account access or account verification information, right? Email plus password, email plus security question, social security number plus driver's license number. It's usually some combination of two elements that would allow someone to access an account. Now, when the CCPA first came out, they said a data breach applies to personal data. Name, phone number, email, address, anything. And so this new law has actually ratcheted that back while amping up the penalties. So it's basically saying, look, we're taking this more serious because we're going to slap you with a larger fine, but we're going to actually limit the liability. So if you just have a breach of a email, or excuse me, let's say you have a breach, a spreadsheet that has marketing contact emails for a newsletter, that may not constitute a data breach under this new law. So hopefully that can give people a little bit more protection, because that dictates how you would store your information, right? Trying to keep these things separate so that if somebody did break in, they wouldn't have access to everything and thereby create a breach. Now, the last interesting thing under the CPRA, this should make everybody sit up a little bit more straight in their chairs. They are establishing a new regulatory enforcement body. So literally, if you go to the law, right, and I said a couple slides ago, I got the hyperlink in there, the law written in legislation, they are going to create a California Privacy Protection Agency. If I remember correctly, their budget is $10 million for the first year and then $5 million a year after that. So if you live in California, hey, your taxes might go up. That's your problem. But for the rest of us, what does that mean? There is now an agency specifically dedicated to enforcing this law. They are pretty well funded, so that probably means they're going to hire a decent amount of people. The other thing to think about, this is a new, interesting area of law, so there's probably a lot of new grads from law school trying to make a case or career on this stuff. So again, right, this is sort of shifting the balance of power. It's no longer, ooh, let's cross our fingers and comply and hope nobody finds out. Now there's going to be a protection agency out there looking, scanning the internet, making sure people comply, reading and receiving consumer complaints. So it's a little bit stronger, more enforcement. Today, right now, it's just the California Attorney General. And so as you can imagine, they got a million different things going on, especially with the state of the world today. Privacy enforcement may not be the top of their agenda, but for the new agency, that's going to be their only agenda. So now we're shifting into what are consumer rights. And again, I want to stress this because I find it can get weird. There is no real strongly, clearly defined list of rights under the CCPA, right? Or the CPRA. If you click the links that I've got in the slides and you actually look at the legislation, like I told you, I'm looking at it on this screen, it's just a giant block of text. So when I say there are consumer rights, what I mean, and presumably what other folks mean when you see this out on the internet, is that they have distilled this law, right? They've read through all of it and tried to create some handy tips. And so I'm saying all of this to say, guys, that if my slides say there are 5 or 6 consumer rights, I've done my best to try to bundle them in a way that makes sense so that we can understand them and also so that we can deal with them. You might find another marketing, blog, content, whatever out there on the internet that says there are 7 rights or 10. There's a million different ways to skin a cat, right? But like I said earlier, all of these laws deal with the same fundamental elements of notice, access, and transparency. So one of the rights, you could maybe carve this up into 2, is the right to know and the right to be informed. Basically that when people give you their data, they should know what they are giving to you and why, right? And I always think my classic example is back in the day when I used to shop at the mall. You go buy something at the store and they say, hey, can I have your email? Why? I'm here, the product's there, I have cash. It says worked for thousands of years. That's what we're talking about here, right? The right to know and be informed is basically explain to people what you do with their data. So if you parse through the language of the CPRA, you'll see this is exactly what you have to say. And I'm putting it in this bundle. The next slide will be similar, because to me, this is what you should put in your privacy notice, right? Nowhere in the law, or that's not fair, I should say, in various places of the law, it outlines what is required in your privacy notice that is posted online. And that collectively is known as this right to know or right to be informed, right? So like I said, if you're looking in the legislation and you're searching, it's not going to say the right to know. It's going to say in various areas that you have to tell people this kind of stuff. So I tried to put it all together on one slide, my logic being, hey, if you want to review your privacy policy posted online and see if it will comply with this new law, this is the kind of stuff that needs to appear in there. And hopefully, going back to that GDPR question, it should be similar to the kind of stuff you're already stating, because it's the same kinds of stuff, right? What data do we collect? What do we do with it? Who do we give it to? Why? That kind of stuff.
So Preston, another question just came in, I think about this in the context of, Facebook and how they manage or don't manage our information. But the question is, if information is hosted by a company under Section 230, that has someone else placed the information there, is that data covered in a request to that company like Facebook? Thinking, do I have this correct? If I was covered as California resident and requested Facebook take some action under the obligations of the CCPA, the company would only have to take action on what the company collected, but not other information that might be hosted on their systems.
Gosh, that's an interesting question. I I would say that's where my mind goes. Yes, is like it would be the information that the company has collected. And the reason I say that is because under this law, they would not consider public information to be personal. And so, for example, if I am, let's say I get on Facebook and I regularly make all these different comments everywhere, and I say, hey, Facebook, give me a copy of my data. I will admit, I think that's a tricky question because now Facebook is going to say, well, hey, we've got your profile, we've got your name and that. Do we have to chase down every comment you've ever made everywhere across the web page? That's tricky. And honestly, I'm not confident saying an answer on this because I want to say from my experience that a court in Germany said something like that. Like,
Right.
like for example, if somebody says, hey, give me all the times you used my name, do I just have to say, hey, I've used your name, or do I have to give them all 30,000 emails with their name on it? And I want to say that a court in Germany said, you got to turn over all those emails. So I'm hesitant, and I admit that's a good question. I would honestly ask that person to reach out to me directly because I'd like to take that forward. Now, they mentioned Section 230, and that makes me think of, I can't think of the name of that act, that law, but I know it's been in the news lately for publishers and how content is managed online. It's tricky because this law also says you wouldn't have to delete information if that impinges free speech. So you know what I mean? Let's say I make a stupid comment on Facebook. Facebook maybe says, I'm not going to delete that you made that of your own volition, and that's part of the communication record. And we could maybe redact your name, but we're not going to delete the comment. So I know that's not a great answer, but that was a good question. That was a tricky one.
Thanks.
Sure. And so this slide, guys, same kinds of thing. That's why I bundled it under the same right. But this to me is what you would want to have on that DSAR process we talked about earlier, right? Consumer requests, consumer demands. Within 45 days of receiving a verified request, you have to be able to spit this kind of stuff out back to people. And then, of course, you see at the bottom, if you are engaged in the business of selling data, you also have to be able to tell that kind of stuff, right? So if I collect data, what did I collect? What did I do with it? If I sell data, what did I sell? Now, the tricky thing on this slide is that element at the beginning, right? A verifiable consumer request. The worry that we have, right, is you don't want someone like me emailing Microsoft and saying, hey, it's Bill Gates, I forgot my bank account information, can you give me that again? Right, so when you're gonna have an email address on your website and people are gonna email you in, who knows who they're gonna be, right? And it's tricky here because we're talking about private and personal information. So you don't wanna just hand that over to some stranger on the internet. When somebody emails you a request or they pick up the phone and call, you have to think through, how are we going to verify that person's identity? Now, under the CCPA, under the Attorney General's guidance that they've released, and you can find that on their website, it's like oag.org or something, but I could point you to that. The Attorney General has said for the CCPA, if people are looking to exercise their data rights, you need to validate two pieces of information, right? So you look at what data you have, pick two elements, and go back to the person on the internet, on the email, say, hey, I need you to verify these two things. Maybe it was the last time we communicated, or what is your address, or your alternate ID, or maybe you have them log into their account, what have you. If they want their data deleted, or it relates to sensitive data, then you need to use three pieces of information to verify, right? So that's kind of the guidance. I think that would bleed forward into this law. How would I verify someone's identity? You want to be able to prove you've matched it to 2 or 3 data elements, depending on what specifically they've requested, right? And that's sort of the rule of thumb. The more info they want, the more they want to delete something and make sort of a permanent change, the more you need to verify their identity. so that you don't create a mistake or inadvertently create a data breach, right? Email the information to the wrong person. Similar to the right to know is the right to access data, right? And so again, this is where these rights they all bleed together, and they're similar, but they're different. So the right to know and be informed, to me, that is the idea that, hey, I need to put a publicly available privacy notice on my website that explains a lot of stuff. Before people even give me their data, I want that notice that says, here's what we're collecting, here's why, here's who we give it to, here's how long we store it. Now, the CPRA has specifically said that that's nice, but we also want to give people a chance to actually reach out and ask you questions. So it's not just enough to post a privacy notice. You actually have to have this outreach, this request, this demand mechanism, right? You have to be able to receive requests related to information, and you need to be able to respond to them in 45 days, documenting it to prove you are compliant. Now, some caveats here. Businesses are not required to provide this information more than twice in a 12-month period. So if you find these to be onerous, if you find you are getting a lot of them, you may institute a process to check so that, hey, if John or Jane Doe is emailing you once every 3 months saying to give me a copy of my data, know that the law is on your side. This is not trying to be terribly, a pain. And so, hey, if somebody emails you more than a couple of times, maybe you respectfully say, hey, we've already provided you this information, hasn't changed. Here is a link to our privacy policy that explains in more detail. We'll talk to you in 12 months. Now, the information must be provided free of charge. And this is where this gets tricky. I should say, not in theory, but people can make it more difficult than it needs to be. In my opinion, like I said earlier, this request mechanism, to me, it is a way to communicate and outreach, right? It is a way to deal with potential new customers, old customers. It's a way to keep people happy, put a smile on their face, and leave a positive image of your brand, right? To that end, right, the law specifically says, hey, you can't charge people for this, or you can't be such a pain in the butt that they can't get the information. I would also argue, why would you want to do that, right? The law was written to protect people so that, hey, if you are economically disadvantaged, if you don't have access to the internet or a computer regularly, that's not going to be a bar to prevent you from exercising your data rights. I would also say that, hey, when you're doing this stuff, there's a lot of nuances where you can get yourself, make life easier, but try to balance that between being the corporate citizen you want to be, right? If somebody does email you once a month asking for copies of their data, yeah, it's annoying, but when you put your foot down and stop responding, that may make the situation worse. So there's a little bit of massaging people in how you reply to these things. And that's what I always try to remind folks when I do this in practice is keep in mind the law says that you have to tell people what you're doing, right? What data you're collecting, who you give it to, but how you reply to those people is entirely up to you. Some companies have forms that they do online, right? You click through and select buttons, and then on the back end, it probably spits into a nice spreadsheet. I want to say, although don't quote me, I think Microsoft's is just an email. Submit an email, web form, generic stuff. God only knows what I could submit. But so again, you think about how do you want to handle this? Are you a B2C organization? Would you get 1,000 of these per day? In that case, you probably need to think through this. In my experience, most people will get a handful of these a month, depending on how they actually sell to customers, right? If it's a B2C over the internet, you could get a lot. Most people in the B2B space, it's a handful a quarter.
Yeah, and here's another question that came in, and
sure.
I think we hear this one pretty frequently. What happens in a situation when federal law conflicts with the CCPA and CPRA data deletion requirements? For example, there are several federal regulations, HDMA, fair lending, et cetera, that require us as a mortgage company to maintain consumer data if any credit decision has been made. A credit decision could be as simple as pulling a credit report as part of a preliminary pre-qualification.
Okay, great question. Great question. And so what I'll answer it in kind of layers. My first one is, generally speaking, you're supposed to defer to federal laws. They're supposed to take precedence over state laws. Now, you're kind of taking me back, because let's say they're wildly different. I don't remember how those get resolved, right? We obviously don't go straight into civil war, but generally speaking, you're supposed to respect federal laws over state laws. It's sort of the law of the land versus the local one. So to that end, I think if someone were requesting you to do something and you were caught between a rock and a hard place, I would comply with the federal law. You know what I mean? And to be as blunt as you can, I would much rather deal with the California Attorney General's office than the FBI.
Yep.
Not that it would get that bad, but.
Right. And we know, from a data retention perspective, you're going to default to whoever requires you to hold that data the longest, right? The objective with data retention is to store data for as short a period of time as possible. So you need to default to your HIPAA compliance, your CPA requirements, accounting. If you're 7 years, 10 years, right? You're going to fall to whichever one of those is the longest.
Yep. And then the other layer to my answer is that this law, I should say both CCPA and the CPRA and many others, generally have specific exceptions for certain federal laws like HIPAA and GLBA and maybe one other I can't remember. But so that would be, so like first layer, hey, generally speaking, federal over state. And in fact, the state of California has inserted that for some specific federal laws. So I would argue that, yeah, hey, if somebody asked you to delete data and you had a federal obligation not to do it, I wouldn't do it. And I would reply to them with that info. Hey, I appreciate your request. Unfortunately, we are unable to delete that because of a legal obligation. I'd throw them the statute just to prove you're not making it up, right? Hey, this is really a law. And that's all you can do, right? And if they don't like it, they can take it to the Attorney General, and then that they can decide. But from my perspective, you would be compliant. And I think that's kind of where I go to that state discussion earlier. Is I think we are in a weird position where the federal government is really trying to get on top of this and set one common set of rules before we have 50 different ones.
Right. Yep. Thanks, Preston.
Sure. And so you can see on this slide, right, the right to deletion, it's something we've seen from the GDPR. It's currently in the CCPA, but both under the CCPA and the new law, it's not an all-inclusive right. There are chances and opportunities where a business would not need to honor someone's deletion request, right? So they would say, they're going to email in saying, please delete my data. And you're going to say, oh, sorry, we can't. And here's why. I would use the language straight out of the statute, which is what you see here. But again, that's where you kind of got to walk that messaging along, because if you think about it, and I'm the best example, you got a grumpy old man who's got nothing better to do, who's emailed you on Sunday saying, delete my data, and you're going to say no. You better have a good reason to calm that guy down as to why and explain to them in detail, right? But you can see there's all kinds of valid use cases when you wouldn't have to delete data: to complete a transaction or perform a contract, to help ensure security and integrity, to debug and identify repair errors, to exercise free speech, right? To comply with some California laws, to engage in certain kinds of research subject to rules. And then you see a last carve out, which is sort of, what does that mean? Solely internal uses that are reasonably aligned with the expectations of the consumer based on the consumer's relationship with the business. Now, I know that sounds like a lot of legalese and a lot of jargon, but the way I read that with my legal mind is, hey, if I've put information in my privacy notice that explains how I'm going to use people's data, then that's what's going to happen, right? And so, for example, let's say you are saving someone's information for accounting reasons, right? Hey, I buy a pair of soccer cleats on the internet from Nike. And I say, hey guys, I received my soccer cleats. You received my Bitcoin that I sent you. And so our transaction is complete. Please delete my data. They might say, hey, Preston, we're not really saving this for a law. It's not like we have a hard yeah, the transaction's over, but we still need to do some accounting, maybe some revenue corrections. So sorry, that's an internal use. And hey, maybe in 6 months, ask us again, right? And so what I always tell people again is think about this concept of notice and access, putting people on notice. That is the USA, the model to this approach. In Europe, it is more of a, hey, you need to deal with data compliantly and you need to protect it. And there's DPIAs and all these rules. Not so much in the US, right? It's much more of a classic laissez-faire model. It's, hey, baby, if there's a sign on the door and if you don't like it, don't come in, right? And so that said, you can't just collect people's data and then hold on to it, use it, misappropriate it, right? Obviously, you should have a desire to keep data accurate and up to date, because from my perspective, why would you want old, out of date data unless it was for some sort of historical research, right? So obviously, if people want to update their information, you should give them a chance to do it. I would even go a step further and actually build this into a regular process, because I think it would make your life easier. And I'll give you an example. I have an account with Edward Jones, the financial institution, right? And once a year, they will send me a packet of paperwork. And it says, hey, Preston, here's all the personal data we have on you. If this is all accurate and correct, you can throw this away. If, however, it is inaccurate, if anything needs to be up to date, this is your annual reminder to go ahead and give us a call, right? And so if you think about it, that's great, because you're almost creating a mechanism to clean your data yourself, right? Don't wait for consumers to reach out to you and update. Do it yourself once a year. If nobody replies to you in 3 years, maybe that email is dead and you can strip it from your marketing list, right? Or get it out of Salesforce or Oracle, because if you think about this stuff at the most basic level, the less personal data you have, the less compliance homework you have to deal with. So the more you can get rid of this personal data, the less you have to explain in your privacy notice, the less you have to potentially hunt down and delete, the less you have to potentially hunt down and correct, et cetera, et cetera. Now, this one is the interesting one under California. To me, it's slightly different from GDPR. I don't know if other states will follow suit. Maybe they will. Like I said, Virginia seems to be. But the idea is that consumers have the right to limit how their personal information is commercialized, right? And it goes back to what I said earlier. If your business model is making money off of my data, it's my data. I should have a right to say, hey, don't do that, or at least give me a cut of it, right? So that's what the law has said here. You have the right to tell a business to stop selling or sharing your personal information. And that's the important change from this current law. The current law today is all about selling. In the future, you have to potentially give people a chance to stop sharing data. And so that becomes, okay, what does it mean to share data, right? Am I giving it to a business service provider for a valid business reason, or am I sharing it to a third party? Depends on the definitions. In a couple slides, like I said, we'll flip to those. But really what this means you have to do is, if you are not engaged in this, you would explain so in your privacy policy, and that's that, right? We don't sell or share your personal information. If, however, you do this activity, you have to put a link on your homepage that allows people to push a button and basically opt out of this activity. Now, it doesn't need to be direct. I think there are some questions on, okay, well, what if I click the button and it takes me back to my privacy notice and then they can email me? That's fine, right? But the idea is you got to give people a chance to opt out of the sharing of personal info. And I think that's going to be very curious to see how that plays out in practice, because like I said, I'm sure there will be more analysis and critical examination of, okay, what is the difference between a sale, sort of a commercialized transaction, versus sharing personal information to accomplish a task, right? For example, you just saw a couple slides ago that you don't need to delete data if you need it to complete a transaction. perhaps the same logic would apply here, right? Hey, I can't stop sharing your data. We're in the middle of a contract. Now, you also see that on the bottom of this slide, sometimes people call this out as its own right. I don't. Again, it's just my style because, hey, why would you do this? Why would you actively discriminate against people for exercising their rights? Basically, the law is saying, hey, you can't be a jerk if somebody asks for their data to be deleted. You can't make their life hell if they want a copy of their data. And again, I would argue, why would you want to do that? You're going to inevitably anger someone. And think about all these people capturing screenshots and sending it to that new privacy protection agency, right? So the last new right under this law, right, I mentioned earlier, is the new definition of data, or I should say personal information versus sensitive personal information. And so you see here that now sensitive information can be controlled and limited in a bit more detail. So businesses should only be using sensitive personal info when necessary to perform a service or provide goods. Basically, if you're collecting sensitive personal info, right, race, religion, ethnicity, political orientation, trade union membership, health info, I would only strictly do that when it's necessary. And if that information is used for any kind of marketing activity, I would say go ahead and get out of that, because that is riskier data. It carries more liability, and I think more and more laws are going to start to walk that back. And as this topic gets more convoluted and complex, I think society will say, hey, there's some data that is very sensitive, and then there's other data that people don't care about so much. So key terms, right? And again, I want you to understand these slides are dense, so don't focus too much on reading them. I want you to take more of the messaging away, but I'm including them for your use later. So one of the key terms is business, because that defines who this law applies to, right? The law applies to a business, and you'll see that term throughout the legislation, but you'll also see other terms like service provider or third party. Those are different entities with different responsibilities. The key one under the CPRA is a business. And if you're familiar with the GDPR, it's very akin to that model. You're sort of the primary one who's responsible for communicating with data subjects, for attaching contract flow downs to service providers, et cetera, et cetera. Now, one of the things that I threw in here is collection. You see that throughout the slides, we've talked about, hey, this applies to data that the company collects. Broad definition, that could mean buying, renting, gathering, receiving. And in fact, you see, this is why I threw it in. This includes receiving information from the consumer passively. So technically, depending on how strict this definition may be interpreted by a court in California, even just passively observing consumer behavior could be considered collecting data. And so the data that you've sucked up is now data under this law, and you have to deal with all the other compliance pieces of it.
Hey, Preston, back on the definition of business there, the
Sure.
question just came in. It says, are nonprofit businesses covered as well? Case in point, a not-for-profit hospital.
Yes. Okay, so here's the deal on that. Under the CCPA, today's law, it does not apply to nonprofits or organizations organized for the financial benefit of shareholders. I'm sort of hung up on that because I had an interesting case once where I'm like, well, a credit union is technically run as a nonprofit, but it is run for the financial benefit of shareholders. But so that's a weird nuance, right? I would say, yeah, I don't think the law applies to nonprofits. And I'm trying to look up under the CPRA, because I think they've made that more clear to try to specifically carve out nonprofits. I mean, this is really meant to apply to for-profit entities. And that's why I'm kind of, I'm partly joking, but partly serious. It goes back to tax revenue, right? If you're making money off of this, Uncle Sam wants his cut so that they can use that to make the market safer. If you're not making any money, I don't know if we're going to hammer you too much.
Right. So nonprofits kind of get away on CPRA, but there's some gray line here with CCPA today.
Mm-hmm.
Yep.
And I think the other thing I would say is, if you are a nonprofit, don't act like this won't be coming. It's not a bad idea to go ahead and adopt some of this stuff. Maybe it's not a burning fire that needs to be resolved, but I would argue something like this will come your way, whether it is from a state law or healthcare. It might be an industry specific law. It might be promulgated by just an industry best practices group. But like I said, I mean, this is going to come for everybody eventually. And 5 to 20 years from now, it probably won't be as big of a deal because we all know it. It'll be old news.
Yeah, I think one of the other things that's overlooked frequently is by implementing these types of processes into a kind of a programmatic solution and being able to have a healthy privacy notice, it really helps those businesses differentiate in the market, right? And it can increase consumer trust. And so now you may be able to gain more consumers, you may be able to retain consumers longer, right? And gain those that you might not have gained otherwise. So I think the awareness is certainly across the consumer market as well. And even though privacy policies or notices can be lengthy and complex, some people do care and they do read them. So.
Yeah, and an important point I think on that, Carlin, is consider the genesis of all of this, right? It was a guy putting a bill in front of people in California. So there has been a lot of public messaging on this topic, right? And I don't live in California, but I know from going to their website that they had all kinds of political ads, right? Commercials and banner ads on websites. I mean, they spent millions of dollars trying to get the word out about this law. So, even a little old lady in Los Angeles may know that she has a right to have her data deleted. She may not know all the nuances, but she's generally aware. And so to your point, I think awareness is growing. I think more people go to a privacy notice as sort of a first point of contact, because I've seen that a lot more in the B2B space. People will refer to that when they want to know about your IT security and your security compliance. They're often going for a privacy or trust center portal on your website to find out, okay, I've heard about these laws. How do you deal with them? Are you SOC 2 certified? Do you have an ISO certificate? Because for most corporate organizations, it's compliance, right? I want to make sure that you're securing my data and then I'll move on with life. It's not quite the same as like, oh, hey, that email from 2 years ago, give me a copy of it.
Right. Yep. Thanks.
So some other key terms here: personal information. And I spell this out with the all different types because I often find that when you're dealing with, no offense, when you're dealing with sales and marketing people, they have this this weird magical sense to never collect personal data, but somehow they're getting all this stuff done, right? And so I've had all those conversations where I'm like, hey, we got to do privacy stuff. And they're like, oh, well, we don't collect personal data. So you don't collect any names, email addresses, IP addresses, cookies, biometric data. You see some other weird ones here that we call out, right? Like browsing or search history or interactions with the website. So hopefully that perks the ears of some marketing people. Geolocation data can get tricky, especially if you have mobile applications that just collect that to help the app kind of work. Professional, employment, or education related information. Now, hopefully some of you are saying, now, wait a minute, Preston, earlier you said employment-related information was exempt. And it is, and I think there's still some confusion, and I don't even know if we, the legislature, has an answer. What about education information? Kids are more and more doing stuff online, all kinds of accounts and systems that tracks your grades. Well, if I'm 16 years old and I just failed my math test, do I have a right to email my teacher and say, hey, I'm exercising my right to deletion? Probably not. So there's some questions, right? So they tried to make an all-encompassing broad definition so that it covered everything under the sun. And then as you can see, they sort of walk that back with some of the other definitions here, right? So sensitive personal information is a much more specific list. And then we've got publicly available information. So if people are out there shouting on the street corner, that's no longer personal and private. We can kind of use that to our heart's content. The question there becomes, what about on social media where profiles are not public, right? If I post something to my 400 friends on LinkedIn, Is that publicly available, or was I really limiting that to an audience? So there are some questions around data scraping there, but I know there's been litigation on that in the past. And if that's something your organization engages in, I would say, hey, double check yourself. But to be clear, the point is that, hey, these laws are written with broad definitions of what would be considered personal data, and thus what is encompassed under the terms of compliance. So the last and most important thing, right? What does it matter for me? Well, you can get in trouble by civil penalties, and that basically means either the Attorney General or that new privacy protection agency would bring a lawsuit against you. And you see that civil penalties are capped at $2,500 per violation or $7,500 for intentional violations. What would mark the difference between that two is going to be a variety of mitigating circumstances, right? And so presumably your own legal team would have a sense of that. It's the same general stuff I think we would all handle in our day-to-day interactions, right? If somebody's a jerk to you, you're probably going to be a little bit of a jerk back. If it looks like you've been flagrantly violating these rules for the past couple of years, you're going to get smacked a lot harder than a company that has been able to demonstrate it has taken steps. Right. And much like with our discussion earlier on data subject requests, if you are doing your best to honor and respond to these timely, politely, I don't think anybody's going to give you too much flack, because that's wholly different from companies where I email, delete my data, and it goes to a black hole and I never hear from them. Right. So really, if you think about it, and if you're sweating bullets over these laws, my advice for you to be, take the target off your back, right? Start making steps today to demonstrate you are doing the right thing and build over time. It's a big deal. It's complex and convoluted, but it doesn't need to happen overnight. I would say taking a first step is better than nothing, because if there is an accident, and how is it going to happen if there's a data breach and you have to tell somebody, you would rather want to show that you've tried to do stuff than hoping and waiting with fingers crossed that maybe the law wouldn't apply. So then the last, sorry, go ahead.
I was going to say, yeah. Well, so what happens if, you're a business, you're not in California, but you're doing business in California, and now you're not compliant? What is this new DPA going to do, and how are they going to come get me out of Colorado? And
Yeah, great question. So my guess, and I'm kind of firing from the hip based on like legal background, experience, having some of these. My guess would be that they would send you some sort of written letter. Maybe it would be over email. I would imagine they try to do both, like one formal written to your registered corporate address, the other one maybe outreach over email. And they would probably try to explain what has gone on. And the way the law is written, they give you 30 days to cure. Now, the question is, what is a cure, right? Because if I have a data breach, the cat's out of the bag. So there's probably nothing I can do. Whereas, if John or Jane Doe was emailing me and it got testy, and then I could probably still handle that, right? So they're supposed to give you a chance to sort of fix it. And the idea is that if you do not fix that stuff they've specifically addressed to you, they will then come after you for that. So to that end, they're not going to jump out of the bushes and sue you. They're going to basically say, hey, we've received a complaint. It's going to go through our process. You've got 30 days to address it, respond, what have you. And if it continues to devolve and it hasn't been resolved by that point, they might start moving towards financial penalties or an injunction to kind of get you going.
Yep, sounds good. Thanks.
Sure. And part of my logic there, folks, is think about this. The major companies at issue in these laws, we all know their names: Facebook, Google, insert other Silicon Valley companies. They're multi-billion-dollar companies with armies of attorneys. And so the Attorney General's office, presumably the Privacy Protection Agency, they know that if they're going to go to battle with a company, if it's a small company, yeah, maybe we'll be out of there for 50 grand, and that's great. If it's going to be a major corporation like Facebook, that is going to be a war that drags out for years at taxpayer expense. And so when these agencies try to find violations, they want to know that they have an airtight, open and shut case. They don't want to get caught up in areas of gray and he said, she said. They want to know You screwed up. You definitely did it. It was you. Case closed. Write the check, right? Because otherwise it devolves into litigation. It costs them time and money. And so in my experience, they're usually going to be looking for the most egregious violators. So what I would say, back to the question, right? If you're based in, let's say you're in Colorado, but the law applies to you and you're violating it, they would probably send you a letter. If you kept violating it, they would probably send you a summons to appear in court. If you didn't appear to plead your case, you would be found guilty in absentia. They would issue a fine. And then the question becomes, how do they enforce that fine? Maybe they jack with your ability to sell stuff on the internet. It could be that they just pick up the phone and call the Denver sheriff and they say, hey, we've got a valid warrant for Preston Bukaty in Los Angeles County. Will you honor and respect that warrant? And they'll say, yep, great, we'll go pick him up or, get the fine or whatever. But that's typically how it works, right? And you can see those examples in a criminal case, right? If I go to New York this weekend and I get a DUI, I can't just escape back to Colorado because we're all Americans. They're gonna find me. Now, if you want, you could go to your Brazils or Panama and maybe get away with it. But at that point, you're probably spending more money and effort than it's worth. So the last thing I have here before maybe we'll open it to questions is just this piece on the private right of action, because this is really the thing that woke people up with the CCPA. Now it's been watered down a bit because it is so scary to businesses, but the idea is that people can actually sue you. So current laws today, right? Most data breach notification laws, if you have a data breach, let's say in Rhode Island, only the Rhode Island Attorney General can come at you. Now, if you lose someone's data, let's say you lose their social security number and a hacker in North Korea buys an RV for 50 grand, you might have to pay that person back because that was kind of your fault, but they could not sue you for it, right? They'd have to show up with a receipt that says, hey, Kim Jong-il bought a Winnebago in my name using the data you lost, here's the receipt. Well, in California, they're saying, if you lose information, even if it doesn't cause any actual damage, they can still sue you for up to $750. Not very much based on an individual, right? You'd probably pay more in attorney's fees, but think about a class action. So if you have a business in Colorado and you sell into California, let's say you have 10,000 customers in California. If you have a data breach, that's 10,000 times up to 750, right? So that's potentially $750,000. And that's why this law is scary, because it is shifting the onus of enforcement away from the government, which historically is understaffed, underbudgeted, maybe don't have enough time and energy to chase this, shifting it into the power of the consumer, right? So if you don't honor my request, you don't do what I do, I can pick up the phone and scream and yell. I could also maybe take you to court. And so I recognize we're getting close to the top of the hour. I know that was very dense material. And like I said, I hoped to jam a lot of content into the slides so that you could use them later. I'm also happy to talk to people at length now or later. My contact information was included there, but I'll perhaps shut up for a second and see if there are any questions that have continued to roll in.
Yeah, thanks, Preston. I don't see anything right now. We've been answering questions in the chat as well as the Q&A. And if anybody else has any further questions, please feel free to use either one of those mechanisms right now. We'll give you a few minutes here. I know another question that kind of comes up is, if I'm CCPA compliant today, how big of a leap is it going to be for my business to get to CPRA compliant? And, I've got some time here, a couple of years, but is that a heavy lift or is that pretty small?
It's really pretty small. If I had to paint with a broad brush, I would say that the differences between the CCPA and the CPRA are minor nuances. And a great example, I'll go back to a slide here, is like this one. I don't, for anyone that's interested, I have essentially the same slide, but retro dated to today. So like this is the CPRA, I've also got the CCPA. There's some minor differences, but it's all the same kind of stuff, right? And like you can get caught up in those differences, but what I always tell people is, hey, step back and look at the bigger picture. What is the point of the privacy notice? to explain what you're collecting, why, what you're doing with it. If you hit a lot of those common elements, you'll probably nail most of this stuff. And so to directly to the question, if you are confident you're CCPA compliant today, there's probably not much you have to do to get ready for the CPRA. I would say go through it with a fine tooth comb and just make sure, for example, that your right to opt out button maybe has updated language, right? If that now applies to you. But other than that, it's going to be the same basic thing. And partly the reason for that is, you know, they couldn't deviate too far from what was in place today. This is a new law that went straight to the voters, but they couldn't rock the boat too much because then companies would just be caught in this game of compliance. You know, some people have already spent a couple of years trying to comply with the CCPA. This is in that vein. It's just slightly more, it's slightly more consumer friendly, but it has also raised the threshold to hopefully apply to more large companies that truly monetize and profit off of data, not the small mom and pops, not people who just have employees in California, that kind of thing.
Great. Well, I think that wraps it up for the incoming Q&A. I think that was all we had. Preston, thank you so much for your time. Appreciate it. I think this was very informative, and I think you know, our ISSA community appreciates this. Got a lot of kudos here coming in from folks on text and Slack and so forth. So great job. Thank you very much. Very applicable. And we look forward to having you back again as things evolve here. Appreciate it.
Yeah, of course. Thank you.
Yeah. So Scott, back to you.
All right. Thanks, everyone. I appreciate attendees. Real quick, thank you, Carl, and thank you, Preston, for this event. There was a lot of sensitive information there, a lot to unpack. I'm actually liking the way some of those rules are going and some of the information presented. For those attendees, I've got a link already set up, so I'm going to send you guys a link to the recording of this video along with the contact information of Preston and Carla in case you have individual questions you'd like to ask them. So I appreciate it. Thank you guys, and we look forward to the next event in a couple of weeks. Thank you and goodbye.